Okay, whenever you're ready, Chris.
Okay, attention, we are live in 3, 2, 1.
Good afternoon. This is Vice Chair Ricky Bauman calling the Hillsborough County Land Use Appeals Board meeting to order at this time, 1:30 p.m. I'd like to introduce the staff and board members. Mr. Hisney, are you with us today?
Yes, sir. Is he or just me? Did he ask if I was here?
Ms. Rodriguez?
Yes.
Enter off. Enter set.
Mr. Clark?
I'm here.
Mr. Campbell?
Present.
Mr. Cornelius?
Here.
Mr. Evans?
Present.
Mr. Schwartz?
Present.
Mr. Smith?
Present.
Is Mr. Hindi here today?
Present.
And Ms. Desiano?
Yes, I am here.
At this time, we will call for the election of the chair and vice chair of the Land Use Appeals Board.
We have to swear the new members in
Oh.
first.
All right, let's do that then. Thank you. Please proceed, Ms. Rodriguez.
Will the new members, it's Ms. Desiano, and will the new members please stand and raise their right hand? And please state after me collectively in the appropriate pauses. And when appropriate, please state your name. Please state your name.
Dallas Evans. I, Dallas Evans.
I, Stanley Hind.
Do solemnly swear
Solemnly swear
Square.
that I will support, protect, and defend
That I will support, protect, and defend
the Constitution and government of the United States
the Constitution and government of the United States
and the state of Florida,
and the state of Florida,
and that I am duly qualified to hold office
qualified to hold office
under the Constitution of the state
under the
under the
Constitution of the state,
and that I will well and faithfully perform the duties
that I will well
and that I will well and faithfully
duties
perform the duties
of the Land Use Appeal Board, which I am now about to enter.
of the Land Use
of
Appeal
the
Board.
Land Use Appeals Board, which I am now about to enter.
Thank you. You may be seated. And Madam Vice Chair, if we can please do a roll call to establish quorum with the new members being sworn in.
Thank you, Ms. Rodriguez. I, Ricky Bauman, am present. Mr. Campbell?
Present.
Mr. Cornelius?
Present.
Mr. Evans?
Present.
Mr. Schwartz?
Present.
Mr. Smith?
Present.
And Mr. Hindi.
Present.
Am I pronouncing that correctly?
Hind.
Hind. Okay, good.
You have a quorum, ma'am.
Thank you. So our first order of business today will be to elect a chair and vice chair. As you know, Richard Harrison has moved out of the county and has resigned as chair. I am the vice chair. If there is no opposition, I would like to move up to chair.
Madam Vice Chair, I can administer. This is Cameron Clark. I can administer I routinely administer the election of officers. I can handle that for you if you'd like.
Please do so, Mr.
Okay.
Clark.
At the present time, I'll ask for nominations for the position of Chair of the Land Use Appeals Board. There's no need to second nominations. I'll ask for nominations until no more are received. If there is only one nomination, that person will become chair without a vote. So I'll ask first for nominations for the position of chair of the Land Use Appeals Board.
This is Bradley Cornelius. I'll move to appoint Ms. Rookie Bauman as chair.
Okay, Ms. Bauman is nominated. Are there any other nominations? Okay, seeing no other nominations, Ricky Bauman is elected as chair of the Land Use Appeals Board. Next, I'd like to ask for nominations for vice chair of the Land Use Appeals Board. Do I have any nominations? Do I have any nominations?
I would like to nominate Jerry Campbell as vice chair if he would accept.
Thank you for that nomination, but I'll respectfully decline. Thank you.
We will require a chair, or vice chair rather, so is anyone, any other nominations?
And I would nominate Mr. Smith as vice chair. I know he has served in that capacity previously well.
Well,
Mr. Smith is nominated.
hold on.
You're muted, Mr. Smith.
How's that?
There you go.
Yeah. Look, I have to decline that. I'm about to start some medical procedures that are going to occupy a lot of my time in life. So I would decline that, but I would ask any of the new members, is there anyone that happens to be a lawyer? Is there a lawyer on the board anymore? And I would point to that person. Have we no lawyers on the board?
I believe
Not-
that Mr. Harrison was our only lawyer, unless I'll let Ms. Rodriguez speak to that.
Not at this time. We do not have an attorney on the board.
Mr. Clark, I'm going to go down the roll and do it that way. Mr. Cornelius, I would like to nominate you for vice chair of the board.
I'll accept the nomination.
All right, Mr. Cornelius is nominated. Seeing no other nominations, I think that's, we've got a vice chair for Mr. Cornelius.
Thank you, Mr. Clark. Let me relate the rules and regulations for the appeals hearing. This board is an appellate body and shall only consider the land use hearing officer's decision and the record. This hearing shall be limited to the record on appeal as defined in LDC 10.03.03.h and consist only of limited oral argument based upon said record. No additional evidence may be submitted or considered by board members. The order of presentation will be staff's introduction, petitioner's case, opposition's case, rebuttal by petitioner. Only the following have standing to appeal or to intervene in appeal which is filed or may be heard at this hearing: the applicant, the administrator, any person or entity which appeared before LUHO and presented testimony or other evidence or presented evidence themselves or by proxy to LUHO and was adversely affected by the decision of the LUHO. The board reserves the right to limit presentation to 10 minutes per side. This time limit may be extended for good cause. Pursuant to this reservation, the presentation is hereby limited to 10 minutes for each side, with rebuttal limited to 5 minutes. The basis for a good cause extension: case reasonably requires additional time. Proposed additional presentation is relevant. Proposed additional presentation is non-cumulative. Amount of time used to answer board's questions. The board shall have the authority to uphold the land use hearing officer's decision or to remand the case back to the land use hearing officer. If the board remands a case back to the land use hearing officer, the board shall specify the reason for the remand and specify the issues for the land use hearing officer to address. Mr. Clark, I understand you have a presentation for us today on the applicable laws.
Yes, very briefly, Madam Chair. I'll go over just very briefly our standard of review for these cases and then very briefly describe the sunshine law, which we do an update of periodically, probably do try to about once a year. And primarily for the benefit of the new members, I know that the existing members have heard this stuff before. So the standard review for these appeals is this board will not be substituting their opinion for that of the hearing officer. They'll be looking at several criteria for these cases. One is to ensure that procedural due process was satisfied, that primarily being issues such as was the hearing properly noticed, was notice accorded before the hearing. Next, it would be whether the hearing officer's decision was based on competent substantial evidence. For instance, with the variances before you today, for variances to be approved, the hearing officer has to find that competent substantial evidence was submitted to satisfy each of 6 variance criteria. If all 6 are satisfied, can a variance be granted? If a variance is denied, then what that means is the hearing officer did not find substantial evidence in the record to satisfy all of the 6 criteria. And finally, to ensure that essentially the essential requirements of law were satisfied, that being the provisions of the Land Development Code and other applicable state and local law. And again, the function of the board is not to say that this board agrees or disagrees with the hearing officer's decision. Essentially, the board could find that there was competent substantial evidence in the record to support the hearing officer's decision, even if the board disagrees with the decision, as long as that evidence was entered into the record. That's enough to satisfy, to uphold the hearing officer's decision. Competent substantial evidence is evidence that a reasonable person could use to conclude that, to reach a conclusion on something. It's not conjecture, it's not circumstantial, it's something that a reasonable person could rely upon in reaching a conclusion. So that is your standard of review. As for the sunshine law, members of this board can only communicate with each other about cases, about the issues that come before this board in this setting, in a noticed setting, such as the hearing that we have right now. Members could not communicate with each other about cases outside of this setting. That doesn't mean members of this board can't communicate with each other. Certainly, if people want to talk about how great the Rays are doing or other issues like that, you're certainly able to do that, but you just can't talk about issues that could or potentially could come before this board outside of this publicly noticed setting. And that's all I have for the presentation. And so I'll go back to you. Thank you, Madam Chair.
Thank you, Mr. Clark. Ms. Rodriguez, are the cases ready to be heard?
Did you want to approve the minutes after the hearing, or would you like to do them before?
Actually, I think we should just do the minutes earlier. That would be good. Has everyone read the minutes from the April 9th LUAB meeting? Does anyone have any errors or omissions or corrections to those minutes? If not, I would like to ask for a motion to approve.
I move to approve the minutes.
All right, Mr. Campbell has made the motion to approve. Is there a second?
Chair, I'll second.
Mr. Cornelius has made a second. Is there any discussion over the minutes? All approving, say aye.
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 That is unanimous. Thank you. Minutes are approved.
Okay, so we'll go to page 2 of your agenda. Item 1A, appeal number 210721. This appeal was withdrawn yesterday from the appellant. Go to page 3, appeal number APP 21-0852. petition file number variance 200496. The appellant is Raymond G. Savoy as trustee of the Raymond G. Savoy Living Trust. The property owner is Raymond G. Savoy as trustee for the Raymond G. Savoy Living Trust. The representative is J.T. Creamer from Stearns, Weaver, and Miller. The petition request is to appeal the decision of the land use hearing officer who denied 4 out of 5 variances requested. 1, to increase the maximum impervious surface. 2, to reduce the building front setback from the west along Ridgewood Avenue. 3, to reduce a landscape buffer along Brandon Boulevard as required by the SR 60 overlay. And 4, or to reduce a landscape buffer between off-street vehicular use area and a property boundary not fronted by road right-of-way, north and east parcel lines. The location is 702 East Brandon Boulevard. The size of the property is 0.59 acres more or less. The existing zone is CG and SR 60. The future land zone is, land use is office commercial -20.75 FAR. The service area is urban, and the date of the land use hearing officer hearing was February 22nd, 2021. And again, this case was continued from the August 6th hearing as requested. And is there anyone here to speak on behalf of this case? Please come forward. Will everybody be giving testimony?
Possibly.
Okay, can you stand and raise your right hand? Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. State your name and address for the record.
My name is Jessica Eiserman. My address is 401 East Jackson Street, Suite 2100, Tampa, Florida. I am an attorney with Stearns Weaver Miller. I am representing the applicant today. With me also is Amanda and Justin Wright. They are the contract for deed owners of the property, as well as the business owners for the businesses that are on the property. So we are here today to.
Well, I think staff needs to present.
Okay.
Did you need to present?
Yes, hi, Tom, Hisnay Development Services. Sonia did a very
We
thorough
need the
job.
oath of office, or the oath, please.
Sorry.
Excuse me?
I didn't hear the oath.
The oath of what? Yeah, I gave the oath.
Okay, my apologies.
No problem.
Sorry. Madam Chair, this is Cameron Clark with the County Attorneys. Can I interrupt real quick?
Please repeat, I didn't understand.
Can you hear me? Hi, can you hear me? This is Cameron Clark.
We can hear you.
We can hear you.
Okay, I just wanted to speak to something in the record real quick. Just an email I got from Mr. Cornelius I wanted to speak to very briefly. Mr. Cornelius asked a question before the hearing via email regarding a potential conflict of interest. He stated he had an association, a professional association with the applicant's representative, Mr. Kramer. They have a common client apparently between their firms. And so they sometimes coordinate in support of the common client, but there's no financial connection there. And there's nothing about any sort of interest in the outcome of this case before you. Looking at this, I don't think that there's any rationale that would require Mr. Cornelius to recuse himself from this case, but I wanted to make sure that was in the record because I think it's a very important and very sensible disclosure. And since we have everyone here, it would be probably worthwhile at least to make sure that there's no parties who object to, just on the interest of safety, making sure there's no one who objects to Mr. Cornelius's participation in this case. Madam Chair, if you would be willing to inquire with the parties who are present today just to ensure that no one has any concerns about that. If the answer is no, then we can proceed as usual. And honestly, just in the interest of prudence, in case anyone does object, then Mr. Cornelius can just recuse himself from this particular application.
Thank you, Mr. Clark. Is there anyone that is a party to application 21-0852 that is looking to have Mr. Cornelius recuse himself from this hearing?
The appellants do not object.
Then we will proceed. Thank you.
Yes, hi, Tom Hisnay, Development Services. Sonia did a very thorough job of explaining the matter that's before you today, so I'll withhold comment and be available for any questions you might have.
Ms.
Can I
Ice,
proceed?
Thank you. I look forward to the day when we are in one room again. And we could take physical cues as opposed to waiting to, for our next chance to speak. All right. Well, thank you all for your time today. We are here today to appeal the denial of 4 variances and request a remand to the LUHO for reconsideration. The property at issue contains 2 businesses, an auto repair shop and a hair salon. The auto repair business operates out of a former gas station, which was constructed in the 1960s. Likewise, the hair salon operates out of a structure which was actually constructed about 100 years ago in the 1920s. The Wrights expanded the business. The Wrights, again, are the business owners. They own both the auto repair shop and the hair salon, and they are with me today. If you have questions I cannot answer, they are here to provide answers for you. They expanded their business, their auto repair business, by adding metal structures on the east and west sides of the existing 1960s building. Unfortunately, they constructed these structures without obtaining necessary building permits. Now they are seeking to correct the violation. And going through the site plan review process, they discovered that variances were necessary to allow for the business expansion in the way they had envisioned, and to accommodate for the construction of an ADA compliant ramp, and to improve pedestrian and vehicular safety on the site. Accordingly, 5 variances were sought, and those 5 variances were discussed and mentioned earlier today. On February 22nd, we went before the LUHO to request those 5 variances. A corrected LUHO decision denied 4 of those 5 variances, and that was issued on April 19th, and this appeal timely followed. A remand is appropriate here for 4 main reasons. First, the LUHO made findings that the unpermitted expansion created a self-imposed hardship, which is an improper finding and not consistent with law. Second, the LUHO failed to make any specific findings as to criteria number 4 for the variance review criteria. Third, the LUHO relied on an improper site visit and facts outside of the record without any opportunity for the applicant to rebut or respond to those facts or assumptions. Fourth, the LUHO failed to apply the practical difficulty test. All of these amount to either a failure of competent substantial evidence or failure to follow the essential requirements of law. So I'd like to take those one by one. First, the LUHO order found that because the business was expanded prior to obtaining permits, the hardship was self-imposed. This is incorrect. An after-the-fact variance does not amount to a self-created hardship. If that were the case, a LUHO could never grant an after-the-fact variance, which is actually a quite common occurrence. In fact, the applicant would have sought these exact same variances regardless of whether the improvements were constructed prior to submitting the variance application or after. The hardship is not claimed as being financial for the cost of taking down the structures. Rather, the hardship deals with the nature of the property, the types of uses on the property, the fact that there are 2 businesses sharing 1 parcel, and the fact that those structures were constructed and located on the property well before any of these regulations ever came into existence. The LUHO improperly relied upon this after-the-fact nature and almost all criteria to justify the denial of the variances. This is an incorrect application of the law. The LUHO should have looked at the particulars of the property. Second, so this is the second reason that a remand is necessary in this case. For each denied variance, the LUHO order made no specific findings as to criteria number 4, which is the requirement that the variance be in harmony with and serves the general intent and purpose of the Land Development Code and Comprehensive Plan. The Lujo order only set forth conclusory statements, when in fact the only evidence on the record shows that each variance is in harmony and does serve the general intent and purpose of the Land Development Code and Comprehensive Plan. This case should be remanded with directions for the Lujo to make specific findings as to this criteria. Third, the Lujo herself performed a site visit and made findings based on that visit. I have two major issues with this site visit. First, the site visit was not disclosed during the hearing and no opportunity was given to the applicant to rebut the Lujo's erroneous findings. Due process requires an applicant to be able to cross-examine witnesses and rebut evidence. By performing a site visit and rendering a decision on facts collected at that site visit without affording an opportunity for the applicant to rebut the Lujo's erroneous findings, the Lujo violated due process. Had the applicant had the opportunity, the applicant's engineer would have testified that the building does not create a traffic hazard as the Lujo claims. Second, there is absolutely no evidence in the record to suggest that such a traffic hazard exists. The Lujo, who is not a professional engineer to the best of my knowledge, rendered an engineering opinion as to the building's impact on the site triangles at the intersection of Ridgeway and State Road 60. This was inappropriate and should be stricken. Fourth, the Lujo failed to follow the practical difficulty test. The Hillsborough County Code allows a variance to be granted in cases involving an unnecessary hardship or a practical difficulty. A practical difficulty is a lower standard than a hardship. A practical difficulty test has been described as existing when the requested dimensional change is minimal and the harm to the applicant if the variance is denied will be greater than the probable impact on neighbors if the variance were granted. In this case, the most directly impacted neighbors signed a letter of support of all of the variances at issue. We respectfully request you remand this decision back to the Lujo, and we are available for questions. Thank you.
Does anyone on the board have any questions of Ms. Iserman? Ms. Iserman, I personally do. I know that you do not agree that the Lujo considered the lack of permitting, but in the record, it clearly shows that the owner obtained a variance in 2012, but it regardless made additions in 14, 15, and 16 without permitting. So if you could please explain to us how that makes a hardship.
Again, the hardship in this situation is not the after-the-fact nature of the buildings. Again, we would have sought variances regardless of whether the buildings were constructed at present time or sometime in the future. These variances are necessary for this specific property. And I also want to point out, my clients are under a contract for deed for the property, and in fact, it was not their actions that created the rights of my client. It was not their actions that created that sought the variance in 2012. So essentially, the rights, who again are the contract for deed owners of the property, did not themselves go through the 2012 variance process. Ultimately, in my opinion, the 2012 variance has no bearing on this case. Again, the hardship deals with the fact that the property has two structures, which are one from the 1920s and one from the 1960s, and they are being forced to comply with an overlay that is very restrictive and the structures were constructed well before the overlay ever existed. And for them to comply with these regulations at this time with these existing structures on the property makes it nearly impossible. For example, one of the requirements is a front yard 30-foot buffer. For that to be the case, the client, the property would have to lose the front half of their parking lot. They would lose the canopy, the original gas canopy that was constructed in the 1980s, and they would lose any ability to actually provide the requisite number of parking spaces for both of the businesses that have successfully existed on the property for decades.
This is
Mr.
Jerry Campbell.
Campbell?
Yeah, thank you. This is Jerry Campbell. I had a question. If the structures had been there that long, I'm assuming they were grandfathered in. If your client had not attempted to expand them, wouldn't their grandfathering allow them to hold that property in its condition before they tried the expansion?
That is correct. The overlay is triggered with the expansion due to the amount of money. So essentially, because the expansions equate to a 25% or 50% above the current assessed values of the buildings, it triggers the necessity to comply with the overlay. So we're not talking about a grandfathered situation here. It's the fact that they would like to expand their existing business by adding on to the old building. And to do that, it triggers this overlay, which is an onerous overlay.
Thank you.
This is Dallas Evans. And just out of curiosity, even if the building footprint were not expanded, would that monetary threshold still require application of the expanded buffers?
I'm sorry, could you repeat that? That was a little muffled over here.
Yes. So even without the expansion of the building footprint, it would sound as if the monetary value of the improvements would still trigger those expanded buffers. Is that correct?
I believe I understand your question to be that even if they did not expand the footprint, the monetary value is what the trigger is. Was that the question?
Yes.
Yes, the answer is yes. Even if the footprint did not expand, if they made any improvements that exceeded that value threshold, they would have to comply. And again, compliance would mean them tearing up their existing parking areas to comply.
Are there any other questions for Ms. Eiserman? Thank you, Ms. Eiserman. Ms. Rodriguez, are there any other appellants to speak?
No, sir.
I'd like to hear from Mr. Hisney, please.
Yes, and I'm sorry, I'm having difficulty understanding some of the board members are very muffled, but go ahead, please.
Mr. Hisney, what is your testimony on this case, please?
I'm sorry, I did not understand your comment. Again, it's very muffled in here.
Mr. Hisney, on this appeal, what is your position, please?
I would just point out that there's two sets of regulations that are subject to the that were requested for variance. The property is zoned CG, and then it has an overlay because it's located in the Brandon Boulevard district. A number of the variances that were requested were to standards that are found in the CG district. Others were from the State Road 60 district. I'm available for any other questions you might have.
Do any board members have any questions of Mr. Hisney?
Chair, this is Jessica Eiserman. May I give a quick closing statement?
Yes, please proceed.
Thank you. I just want to point out, this is not the second time you have heard this case. So what is before you today is not a request to overturn the Lujo decision. Rather, it is a request to remand the decision for the errors I described earlier. Thank you.
Thank you, Ms. Eiserman. Members of the board, you have heard the testimony on appeal number 210852. Do I have a motion here to affirm the Lujo, remand it back to the Lujo? Mr. Campbell?
Yes, before any motion, I had a question. I guess this would be to Cameron Clark. There is much made of the fact that the hearing officer went out to the site on their own. And I guess my question is a hearing officer allowed to do that under the guidance they're given as far as the case goes? And if they do use observations on a site visit that's not noticed and the appellant doesn't have the opportunity to be there and refute anything, are they allowed to use any observations, measurements, anything else they make during that site visit to steer their decision? Is that considered proper?
So generally, I would say it's not unusual for a hearing officer to perform a site visit as part of their review during this process. I believe the concern of the appellant is that if there were observations or essentially what the appellant would deem to be evidence that was gathered by the hearing officer as part of that they didn't have a chance to address or in the hearing process, their allegation is that would be improper. I would say that, for instance, if there, you mentioned the term measurements. If there are measurements that are part of the application and the hearing officer went out and made measurements, which strike me as it would be unusual. If there was a disparity between what's in the application and the evidence packet versus what was observed personally, it would be ideal to have that addressed at the hearing so that that could be addressed. I'm not sure, I mean, and the appellant may want to speak to it again, but the specific allegation, the site visit itself not improper, is there are specific pieces of evidence or parts of the hearing officer's decision that the appellant is alleging conclusions that could not be reached based on the record that's before the hearing officer. It would be best to specify what those are, because, for instance, if this board decided to remand to the hearing officer, this board will want to identify as clearly as possible, first of all, what variance criteria we talk about. If we're talking about evidence outside the record, then you probably talk about all 6 variance criteria, but the board will want to identify exactly what it is that the hearing officer needs to look at. So if the appellant is alleging conclusions A, B, and C in the hearing officer's decision, there's no evidence in the record to support those conclusions. I mean, that would be a reason to remand potentially anyway, because there needs to be competent substantial evidence in the record for any conclusions that are reached by the hearing officer. So if the board wanted to remand in order to have allow the appellant to rebut any conclusions or any such thing that were in the hearing officer's decision based on evidence that they are alleging was outside the record of the hearing, it would be best for the appellant to identify that with specificity so that the board can take that decision. If the board finds that that's not the case, that any hearing officer, any parts of the hearing officer's decision, there's nothing outside the record that was based on, then the board could vote to uphold the hearing officer's decision. So hopefully that answered your question, sir. If you have anything else, go ahead and ask.
Well, it's not really a question, I guess it's just a comment. If it's considered acceptable practice for the hearing officer to go out unannounced and look at a site, even if they don't take measurements, it's hard to believe. And the purpose of them going out there is to look around and get a general feel for the site. And even if they don't delineate that in writing in their findings, I would have to think that they're going out there, they're going to be influenced by what they saw, whether they put it specifically in writing and somebody can pounce on it and say, wait a minute, you went out after the fact and you made this observation and made this finding, and that's wrong. And I wanted the opportunity to dispute that. If you're allowing the hearing officers
Sure.
to go out there informally, I don't see how you can't help, but they're going to go out. I'm going to look at a site and I'm going to make determinations mentally about what I'm seeing. But I do appreciate the explanation. I just think it's an odd practice to allow them to do it.
Any other members of the board have any questions of Mr. Clark or Mr. Hisney or at this time? Then I would entertain a motion to either deny the appeal, approve the appeal, or to remand it to the LUHO.
Well, I'll go ahead and move to uphold the hearing officer's findings, in effect deny the appeals based on,
Please state your name when you're making a motion, please.
Jerry Campbell, based on the fact that it sounds like from the record that I read and from the testimony today that the main reason they had to ask for these variances was they basically wanted to expand the site, the businesses at the site. And for those reasons, I'll make the motion to uphold the hearing officer's findings and their decisions.
Is there a second?
This is Larry Smith. I would second that.
Thank you. Is there any discussion on this motion? Hearing none, I will call the vote. Mr. Schwartz?
Yes, I agree. Yes. Yes.
Mr. Evans?
No.
Ricky Bauman, yes. Mr. Hine?
No.
Mr. Cornelius?
Yes.
Mr. Campbell?
Yes.
The motion carries. The decision of the land use appealing officer on applicant 210852 is upheld.
Did Mr. Smith vote? I'm sorry, this is Cameron Clark. Did Mr. Smith vote?
Mr. Smith will vote yes.
Oh, sorry, Mr. Smith.
Okay.
Mr. Smith did second the motion.
Yes, he did. That concludes application appeal number 210852. Ms. Rodriguez, please call the next appeal.
The next appeal is on page 4, item 3A, appeal number APP 21-1053, petition file number variance 210455. The appellant is Greg Barron. The property owner is Greg and Nancy Barron. The petition request is to appeal the decision of the land use hearing officer who denied the request for a variance for wetland conservation area setback as to the proposed 347 square foot encroachment for a deck and pool addition on the subject property. The location is 15203 Leith Walk Lane, Tampa. The size of the property is 1 acre. The existing zoning is planned development. The future land use is R-4. The service area is urban. The community planning area is Greater Carrollwood, Northdale. And the date of the land hearing officer hearing was May 24th, 2021. And sir, please raise your right hand. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
And please state your name and address for the record.
Greg Barron, 15203 Leaf Walk Lane, Tampa, Florida, 33618.
Thank you, Mr. Barron. Please proceed.
Thank you. I appreciate the opportunity to be heard today. This has been a very costly, long, and stressful process for my family, but I'm encouraged because of this process, and I'm encouraged because on July 13th, the Patel family residential compound was granted 12,981 square feet, which is 37.4 times more than our denied 347 square feet, and did it proposing the identical remedy of compensating native plants to offset the impact of building in the buffer. Today, I'm going to try to move as quickly as possible and focus on the specific criteria used for the decision that denied our needed 347 square feet, and will reference the decision criteria concerning the 699 square feet that was approved by the hearing officer on June 14th. On page 7 of the decision, criteria 2 asks, would the literal requirements of the LDC deprive the property owner of rights commonly enjoyed by other properties in the same district and under the terms of the LDC? The decision was no. The hearing officer wrote, the literal requirements prohibit the filling, excavating, or placement of permanent structures in the wetland conservation area, but do not deprive the property owner of rights commonly enjoyed by other properties. Our argument is that the pool is designed to be built up above the soil versus digging down into the soil, impacting only 347 square feet outside of the long existing screened-in structure. That structure is 4 feet high above the lawn, and the design is to build 10 inches higher than that existing deck right now, with a pool depth of only 4 feet deep. So what's going to happen is the most minimal of excavating to just level the ground to be able to do the construction. Staying with criteria 2, the hearing officer noted that the literal requirements of the LDC do not deprive us of rights commonly enjoyed by other property owners in the same district and area. I'm not an attorney, and I'm not competent to argue the literal requirements or the legal definition of rights, but I can, however, point out that the decision clearly deprives my household of the ability to benefit from our home in the way commonly enjoyed by other properties in the same district and area. My understanding is 11 out of 14 homes in the Edinburgh subdivision have pools, and it's fair and accurate to say that the vast majority of similar homes throughout Hillsborough County in similar neighborhoods have pools. I would add that when you look at the long-standing precedents in Hillsborough County, it's appropriate and reasonable to reconsider the decision. On page 7 of the decision, criteria 3 asks, would the variance, if allowed, substantially interfere with or injure the rights of others whose property would be affected by the allowance of the variance? The decision was yes. The hearing officer writes, the Edinburgh subdivision plat requires wetland conservation area to be retained in a natural state and requires the wetland conservation setback to comply with the Hillsborough County LDC provisions. Our argument is based on empirical observations. The majority of the lake is surrounded by homes with lawns in the wetland buffer, and they go right down to the edge of the lake. My lot does, as does my neighbors in Edinburgh and everyone else on Lake Platte. The lawns are clearly not the natural state of the wetland conservation area. The lake also has a very large church compound with a significant amount of lawn in the wetland buffer. When it comes to the natural state of the wetlands and the intent and purpose of the LDC, getting the variance creates a compelling incentive for me to take actual practical steps that promote the health of the lake and a healthy wetlands by removing sod in the buffer and replacing it with compensating native plants. Those actions are in support of the general intent and purpose of the LDC. Dr. Don Richardson spoke to the long accepted environmental advantages at our hearing on May 24th and are cited in his report. He expressed that the compensated native plants would provide better water quality to the lake, reduce nutrient loading, and provide wildlife habitat for animals that move along the lake shore. Our plans call for providing over 3 times the compensating native plants for the 347 square feet that was denied. The long accepted benefits from removing sod and planting native plants serves the general intent and purpose of the LDC because of the noted benefits to the water quality of the lake, the wildlife, and the neighbors. Should this variance be denied, those benefits will not be realized. Staying with criteria 3, would the variance, if allowed, substantially interfere with or injure the rights of others whose property would be affected by the allowance of the variance? No one's property is going to be affected by the allowance of the variance. The hearing officer wrote, "The owner of the subject property and all other owners of the lots in Edinburgh subdivision are entitled to rely on matters disclosed on the Edinburgh subdivision plat. If allowed, the variance would result in additional encroachment which would substantially interfere with or injure the rights of other owners of property in the Edinburgh subdivision who rely on matters disclosed on the Edinburgh plat." Our argument begins with referencing the hearing officer's June 14 decision on page 8 concerning the approved variance of 699 square feet of what we needed. The 699 square feet is where a portion of the house and a screen enclosure deck was built in 2002 by homeowner number 1. I'm homeowner number 3. The hearing officer writes, "There is no evidence that the existing structures interfere with other properties, even though they encroach into the wetland conservation area setback. The variance is in harmony and serves the general intent and purpose of the LDC." That's the 699 square feet that was granted. You can see there's a portion of the primary bedroom of the house that was built in 2002 is in the wetlands, is in the conservation setback, as is a big portion of this deck. The denied adjacent small patch of grass, just 347 square feet, is no closer to the wetlands line than the approved 699 square feet at its closest point to the line. There's a track record of 19 and a half years that makes it practical and reasonable to conclude that granting the variance for the adjacent 347 square feet would not interfere or injure the rights of other owners of property in the Edinburgh subdivision. The hearing officer's decision on this point was not consistent when examining the conclusions related to the 699 square feet granted and the 347 square feet denied. Additionally, when the context of how things actually work, including Hillsborough County's extremely robust process for notification of hearings on land use variances, it becomes even clearer that this decision was incorrect. In support of the argument, I want to highlight a few facts. The neighbors all received the required notification letter for the May 24th variance hearing, which detailed the process and detailed our proposed plan. The neighbors all saw the huge bright yellow notification sign on the front lawn of the subject property for weeks and weeks and weeks. The HOA board has received ongoing updates about this plan going back to the first quarter of 2020. They completely support the variance and have reviewed and formally approved the plan. They also signed off on permission for the plan to slightly touch the line of the drainage easement and reviewed my neighbor's generous action of moving our property line along the drainage ditch to allow this pool to more easily be built. Prior to the May 24th hearing, the neighbors gathered for the 2021 annual Edinburgh HOA meeting on the physical spot of the proposed pool and discussed the plan. The neighbors have no formal or informal opposition. My last point about this decision on criteria 3 is that my understanding is the purpose of a variance process is to have an appropriate approach for making reasonable exceptions to things such as the Edinburgh Plat and the LDC when those exceptions can demonstrate no harm or interference will come to the property rights of others or the environment. That's clearly the case here. Any conclusion that granting the 347 square feet would somehow substantially interfere with or injure the rights of others who rely on the Edinburgh Plat is incorrect. There's no evidence to suggest any harm or interference with others after 19 and a half years, and there's no opposition by the informed relevant stakeholders. On page 8, criteria 5 of the decision, it asks, does the situation sought to be relieved by the variance result from an illegal act from actions by the applicant or property owner resulting in self-imposed hardship? The decision was yes. The hearing officer writes, the situation sought to be relieved by the variance results from the applicant's desire to add a pool and deck. The applicant's desire to add a pool and deck results in a self-imposed hardship. Our argument is that throughout the decision, the hearing officer states or implies that the owner just wants to add a pool and deck. That characterization is incomplete and doesn't reflect the actual circumstances and issues adversely impacting our household. It's reasonable and practical to reconsider the decision on criteria 4, 5, and 6 because the homeowners have ongoing significant progressive health needs that will be directly aided by granting the variance. This was included in our variance criteria response when we applied for the variance process. It's criteria 6. Because of our strong desire to protect our medical privacy, we minimized that point in our variance criteria response and chose not to share it in the public forum of the May 24th hearing. If it's appropriate, I prefer to provide 3 physician letters versus speaking to those confidential health issues publicly. Looking at criteria 4 and 6, the hearing officer incorrectly concludes allowing additional encroachments is not necessary for reasonable use of the subject property and would not serve the general intent and purpose of the LDC. It is necessary given our health needs, and it is reasonable given the long-standing precedents in Hillsborough County to provide such variances. In this situation, granting the variance will more clearly serve the general intent and purpose of the LDC than denying it, because it will result in 3 times the native plantings to compensate for the impact in the buffer, resulting in longstanding benefits to the water quality of the lake, the wildlife, and the neighbors. It's also reasonable, given the small impact and the hearing officer's conclusions, that granting the adjacent 699 square feet with structures on them for 19 and a half years was in harmony and serves the general intent and purpose of the LDC. Before I close, are there any questions I can answer?
Mr. Barron, this is Ricky Bauman, the chair. This decision is based solely on what is in the record. So if there were supporting documents from physicians, neighbors, or any others that were not supplied in the appeal, they cannot be considered at all. And members, please consider that stricken from the record. With that said, does anyone have any questions of Mr. Barron? Hearing none, thank you, Mr. Barron. Let's hear from Mr. Hisney, please.
May I summarize my arguments, my basis for appeal?
Mr. Barron, after Mr. Hisney speaks, if you have a short rebuttal, you may do that. Mr. Hisney?
Yeah, I'm sorry again, sir. It's difficult hearing some of the board members in this room. No, I do not have any comments. I also would like to point out that Carla Shelton of our Natural Resources staff is available through virtual attendance for this meeting if you have any questions for her or me.
And what was her name again, please?
Her name is Carla Shelton, and she is on Natural Resources staff, who are the ones who actually review requests for conservation wetland setback variances.
Thank you, Ms. Rodriguez. Could you please swear in Ms. Shelton?
Can we see her? I need to be able to see.
Can you
Will
see
you
my
ra-
video? This is Carla Shelton.
Hi, yes, can you please raise your right hand? Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Can she hear me?
Her internet.
It's like she's dropping from the call.
Carla,
can you hear us?
I can hear you, yes.
Okay, raise your right hand. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
And state your name and address, please.
Carla Shelton, Hillsborough County Natural Resources staff.
Please proceed, Ms. Shelton, with any testimony relative to Appeal 21-1053, please.
I have no testimony. I'm just here to answer questions that the board has about the code requirements for wetland setbacks.
Mr. Campbell.
Yes, Carla, this is Jerry Campbell. I have a question for you. If you had a sodded yard and somebody proposed to replace a portion of that sodded yard with native plants and place a structure on the remaining part of it, what impact would that, I mean, would that be a general improvement because they've removed part of the sodded yard and put in native plants? Or would it depend on what kind of plants they put in? My sense is that it would actually improve the water quality in the lake if you remove sodded yard and for any portion of it and put in native plants. Is that generally correct?
Well, the reason that we have a setback from the wetland line in the first place is to provide an area that will allow any impurities in the stormwater to filter down through the soil and the vegetation before it reaches the actual wetland. So taking away part of the pervious area and replacing it with an impervious surface, such as the pool surface itself, takes away a portion of the area that allows for that water filtration to occur. It is true that the native plants would provide better protection from the wetland, for the wetland, than turf lawns, because generally lawns have pesticides and fertilizer applied to them on a regular basis, and the native plants won't require either of those. So that does help with improving the quality of the water as it reaches the wetland itself.
And for my understanding, if somebody has a sodded yard within the wetland setback area, are they somehow I mean, it obviously sounds contrary to the land development code, the 30-foot setback. If I've got a sodded yard inside of that, is that actually considered a violation of the land development code if I've got a sodded yard inside 30 feet?
It's not necessarily a violation. We have numerous wetlands in the county. A lot of the development around these lakes and other wetlands took place prior to our code coming into effect, which was November of 1985. And even properties that were constructed after that date, when this 30-foot setback from the wetlands became a code requirement, it's just not possible for staff to monitor what people are doing in their yards as far as vegetation, maintaining the native vegetation, planting sod, etc. So throughout the county, I'm sure there are a lot of wetland setback areas that have been sodded over the years.
Okay, thank you.
Does any other member have questions of Ms. Shelton? Thank you, Ms. Shelton. Mr. Barron, you may have your rebuttal.
Yes, I would comment that my understanding is that there's a long-standing precedence for providing variances of this type in Hillsborough County, and the process is to provide those compensating native plants on the list approved by the county. I would further say that there's no opposition to the proposed variance by anyone after the rigorous notification process and getting a variety of approvals from the HOA related to various aspects of the plan. The hearing officer's decision concluded there was no evidence of an adverse impact on anyone's rights or the wetlands from the 699 square feet adjacent to the 347 that was denied, even though a portion of the home and the deck has been there since 2002. Furthermore, the plan is to build the pool up, dramatically minimizing any excavating. The rest of the area will be decking, which will allow water to flow through it. The long accepted benefits of the water quality of the lake, the wildlife, and the neighbors will be realized if this variance is granted, and it won't be if it's denied. There's no incentive for me to change anything about anything we've got there unless we get this variance. Not granting the small variance is in conflict with decades of precedents and the July 13 decision to grant a much larger variance of 12,981 square feet on a nearby lake with the same compensating plan for native plantings to offset the 25 feet taken in the 30-foot buffer by that other citizen of Hillsborough County. Last, I would say that a common practice or accepted norm is to rely on the counsel provided by qualified, competent professionals based on the decades of precedents that they're familiar with. That's exactly what we did in our case. That's what happened before we bought the home and asked about the ability to build a pool. That's what happened after we bought the home and spoke with multiple pool companies. They all indicated that we'd be able to do it based on their experience and every other professional that we spoke to and sought counsel from. So I'd appreciate your consideration. And if you have any other questions, I'm happy to answer them.
Thank you, Mr. Barron. Board members, you have heard Appeal 21-1053. We have now time to.
Madam Chair, this is Cameron Clark. And board members, I just want to reemphasize something that the chair just stated, which was important. This is not a rehearing of the original application. The applicant is only able to rely on the record that was submitted to the hearing officer. That's what the hearing officer based their decision on. No new evidence or argument made today has any impact on your decision. It is only whether the evidence that's submitted to the hearing officer supports the hearing officer's decision. And so argument like, there were no neighbors opposed to this are not relevant for your purposes. It's not a popularity contest. It's whether a variance meets the 6 criteria that are in the code, whether evidence was submitted to the hearing officer to support the decision that was made at that level. So thank you, Madam Chair. I just wanted to reemphasize what you just stated. Thank you.
Thank you, Mr. Clark. At this time, I would entertain a motion to either uphold the decision of the land use hearing officer, remand it to the land use hearing officer, or deny the appeal. Mr. Cornelius.
Madam Chair, this is Brad Cornelius. I'd like to make a motion. I motion that the board uphold the decision of the land use hearing officer. I believe she did make the decision based on substantial competent evidence and compliant with law, and I support that decision.
Thank you. Is there a second to Mr. Cornelius's motion?
I would second it, and I would also add the comment that it's interesting because what it sounds like what the applicant is proposing to do and get this variance for may actually improve the quality of the runoff into the wetland, but he's got, it sounds like a non-complying existing use to begin with. A lot of issues there, but I agree with Mr. Cornelius that the decision here does appear to be made based on competent substantial evidence. So I will support the motion.
That was a second by Mr. Campbell. Is there any discussion on the motion?
This is Dallas Evans. I would note that the land use hearing officer did allow that the existing use be continued, just not to expand beyond that.
Did everyone hear Mr. Evans?
Yes. And also to clarify, my motion is consistent with that. The land use hearings officer decision was to allow the variance for the existing structure, only deny the additional expansion in. So we do recognize that.
Is there any other discussion? Hearing none, we will call this to a vote. There is a motion on the floor to uphold the decision of the land use hearing officer on appeal 21-1053. Mr. Campbell?
I support the motion.
Mr. Cornelius?
I support the motion.
Mr. Evans?
I support the motion.
Mr. Schwartz?
I do not support it, no.
Mr. Smith?
I vote no.
Mr. Hine?
I do not support the motion.
And I do support the motion. It carries 4-3. Ms. Rodriguez, I believe that concludes our business for today.
Can you just?
Yes, I just need to state that on page 5, the appeal 21-1079 was out of order, and that's why it's not being heard today.
Thank you.
Can I just ask for clarification what the vote was 4-3?
That is correct, Mr. Barron, 4 affirming the hearing officer and 3 against.
And when will there be an opportunity for me to apply for a variance again? Is it 1 year from the May 24th hearing?
If you were to request an identical variance, yes, you must wait 1 year. I'll have to check to see if it's from the date of the denial. I believe it is. However, if you were to modify your variance to a certain extent, as explained in the code, you could reapply before that 1 year period.
Okay, so otherwise it's either May 24th or June 14th, the hearing date or the signed
1 second.
decision. Thank you.
Mr. Campbell?
What does it mean when it was referred to the 4th case we were supposed to hear was out of order? What does that mean?
It means that they did not send out their notices, so they have to notice the parties of record, and they did not.
Well, with that, I consider our business today finished and
Mr. Hisney is trying to find some information for the appellant. But board members, just to let you know, the next hearing is going to be December 10th. And please mark your calendars. We have two
Board
new
members,
two
you can,
appeals.
Could I give you that information right here after the meeting so
Yeah.
they can conclude the
yeah,
meeting?
board members,
Right.
you can
Right.
adjourn. Staff can provide that information to the appellant.
We are officially adjourned. Thank you.
Thank you.